today's topic, we will be covering Lesson 3.2, Real Property, found in our business law textbook. The goals are to discuss the concept of real property, and to explain the rights and duties associated with real property. Real property, or realty, is comprised of land, buildings, and fixtures. Real property extends from the farthest reaches of the atmosphere, across the surface of the subject area, and down to the center of the earth. The rights to drill or mine under the surface are referred to as mineral rights. In some states, mineral rights can be transferred independently of surface rights. Fixtures are a special category of real property. Fixtures are items that are at first considered personal property. They become realty when they are permanently attached to real property. When the items are permanently attached, the ownership passes to the owner of the real property. Exceptions to this are situations involving trade fixtures. An example of a trade fixture would be a built-in pizza oven in an Italian restaurant at a shopping mall. These fixtures are never intended to become the property of the owner of the real property. When the lease ends, the tenant can remove such property. The powers of ownership of real property vary with the type of estate, or bundle of rights, received upon taking ownership. The words used in the deed, or document by which rights and interests in real property are transferred, control this. The party who transfers the ownership powers is the grantor. The party receiving the powers is the grantee. When an estate is transferred from a grantor to a grantee by deed, the transaction is known as a conveyance. There are two types of deeds. A quicklime deed transfers only the rights and interests that the grantor has in the real property. If the grantor does not have any such rights and interests, the deed is worthless. With a warranty deed, at a minimum, the grantor promises that she or he has good, clear title. In most cases, the grantor also promises that the property is free from adverse claims, and that the grantor has the right to convey it. Types of estates in land and the powers they convey. Estates in land vary from absolute ownership to various conditional ownerships or use. Fee simple absolute. An estate that incorporates all ownership rights is called a fee simple absolute. The owner of it exercises all the powers allowed by law in the real property. Conditional estate. An estate that allows ownership, as long as a condition is satisfied or goes unviolated, is called a conditional estate. For example, land willed to a daughter, as long as it is used for an animal shelter, would be such an estate. Should the land no longer be utilized in the manner required, ownership would return to the estate of the decedent. Life estate. An estate that typically allows its owner the rights of possession, use, and profit for the duration of a particular person's life, usually the holder, is called a life estate. The holder of a life estate cannot waste, destroy, or spoil the value of the property or permanently dispose of it. Non-freehold estate. An estate that involves an agreement to allow exclusive possession and use of the realty is called a non-freehold estate. Such estates are more commonly referred to as tenancies or leaseholds. There are four basic types of non-freehold estates. 1. A periodic tenancy is for a renewable period of time with the rent due at stated intervals. These leaseholds in real property can be month to month or week to week. Renewal of the lease is automatic unless a termination notice is given by the landlord lessor, the party creating the estate, or the tenant lessee, the party using the estate. 2. A tenancy for years is a leasehold for a definite period of time. It is referred to by this name, even though the period of the lease can be for more or less than a year. At the end of the lease period, this tenancy terminates automatically without any further notice being required. 3. A tenancy at sufferance is created when a tenant does not leave on the day the lease ends. The tenant is thereafter referred to as a holdover tenant, and can be held liable for rent for the holdover period, or can be evicted, or dislodged from the premises by the landlord. 4. A tenancy at will is created when a party possesses land with the owner's permission, but without agreement as to rent or duration of the tenancy. Such a leasehold may be terminated at any time with minimal notice from either party. There are many restrictions on the use of the powers inherent in real property ownership. Restrictive covenants included in previous deeds sometimes run with the land. This means they bind later owners to their terms. Zoning ordinances by cities or counties also may restrict the real property owner's rights. Variances, or exceptions to zoning requirements, may be granted by a governmental body, if a property owner shows, for example, hardship or lack of injury to others. Real property also may be subject to easements. Utility companies usually employ these irrevocable rights to gain access across one party's land to reach others with its services. Easements also may be given to a neighbor who cannot reach his or her property without going across another's land. Certain real property owners may give temporary, revocable rights to occupy or use their property to people or businesses. These are referred to as licenses. Such licenses are personal, non-transferable, not inheritable, and not considered an estate in land. A ticket to watch a movie in a theater is an example. If a patron is too loud or becomes unruly, the patron's license can be revoked. Thereafter, the patron can be classified as a trespasser and removed. A trespasser is someone who is on another's property without any right, authority, express or implied invitation, permission, or license. Teamwork in small groups. Choose one of the restrictions on real property, restrictive covenants, zoning ordinances, variances, easements. Brainstorm specific situations in which the restriction can occur. Of course, even trespassers have rights. A real property owner is charged with the duty of refraining from doing them intentional harm. A property owner owes a similar duty to a licensee, and must warn licensees of known dangers, such as guard dogs. Finally, to a business invitee, a person who comes onto property to do business with the owner, the property owner has several duties: to refrain from doing intentional harm, to warn of known dangers, and to conduct inspections to discover such dangers.